Welcome to Passive Investor Ed 2021, the ultimate virtual conference for passive real estate and alternative investments, presented by Kavita Bharatake, Raj Tekchandani, and Ramesh Nachiappan. With our guest speaker, founder of Kaliser and Associates, syndication attorney Merrill Kaliser, on legal structures and documents in a syndication.
Merrill is the founder of Kaliser and Associates. He's also a multifamily syndicator. So we work personally with Merrill on one of our deals in Katy, Texas. And there are some investors on from Katy as well here on today. We've invited Merrill, if you were here a few minutes earlier, to talk about legal structures and documentation in the syndication, because I personally feel like it's so important that people read these documents that they're signing. You're giving away a lot of money, so you should trust your sponsor, but not trust them when it comes to legal documentation, right? You need to be responsible for what you're signing. And so we've had Merrill on to talk about what are the different documents in a syndication, what are some of the things you need to watch out for, and what are some things you can't just gloss over, right? Maybe there are things you can gloss over, hopefully, because not everybody wants to read a 150-page document. He's a founder of Kaliser and Associates. He was born in Augusta, Georgia, and raised in Dallas, Texas. And Merrill still lives in Dallas, but he travels a lot between Dallas, Houston, and Austin, because his kids are in Austin and Arlington. So he received his JD from Washington University School of Law in 1999 and joined Gardier. Sorry if I butchered that name.
Oh, very good.
Okay. As a national and international corporate bankruptcy and restructuring lawyer. That's a mouthful. After 4 years of extensive experience in largest bankruptcy and workouts in the history of our country, he left Gardier for a boutique firm that had significant focus on commercial restructuring and workouts. In 2008, he became a sole practitioner, where his primary focus was corporate, real estate, and creditor representation. I'm excited to have Merrill on. Like I mentioned, he's not only a legal attorney, syndication attorney, but he's also a sponsor. So we've worked very closely with Merrill, have really had an opportunity to see what Merrill is about, and we're excited to have him on here today. With that, I'm going to stop talking. I'm going to hand it to Merrill to do his thing. Thank you, Merrill, for being here.
Thank you very much, Kavita. I'm going to go ahead and share screen. If I could just get somebody to confirm that it will be shared.
Yeah, you can share.
Can you guys see that?
Okay.
All right, let's see if I can figure out how to do this. There we go. So I apologize. I already had a slide, and Kavita did a much better explanation of me than I can do of me. So a little bit about the firm. We have over 13. We've represented over 1,300 transactions in the last 10 years, and those transactions are going to be syndications, mostly multifamily, some storage, and some RV parks. And I would say about 75% of those are acquisitions, and the other 25% are going to be dispositions or sales. Total, I think we tried to total up a couple months ago. It's been over $6 billion in total assets that our clients have syndicated. So it's very exciting. We have 3 commercial real estate SEC lawyers, including myself, and 3 paralegals. I'll just mention very briefly, I have some side businesses in real estate, and I have done over 9,500 single family homes in 5 states over an 8-year period with several East Coast hedge funds. Like the team up here, I'm a sponsor and a co-GP on many deals. Done some development, done some other things. So when our firm talks to investors and syndicators, we kind of wear 2 hats. We help give advice from a business perspective as well as a legal perspective, if asked. Otherwise, it's just legal perspective. And Kavita says I'm funny, so I'm going to try to be funny when I go over some really boring stuff. So next slide. I thought first what I would do is just discuss really quickly the types of funds as an investor you may see. The typical deal, I'd say 85% of the time, it's one asset. It's a multifamily on 123 Main Street. There's going to be a capital raise, and that just means there's going to be a portion of it that's going to be financed by debt, a bank, Freddie Mac, a hard money lender, hopefully not too many hard money lender deals, a bridge lender. There's going to be 70 to 80% financing typically, and the rest is going to be capital. And that capital consists of investors that pool together their funds. You may hear the term SPE. Nothing scary about it, just means single purpose entity. So the entity was actually formed to buy this 123 Main Street asset. Sometimes, and we're seeing more and more of these, and investors may see more and more of these, where you have multiple assets in a fund. So you may have two or more assets, two or more multifamilies that are being acquired. Many times it's the same seller. Other times it's different sellers. So there may only be one, typically there's one capital raise, and that capital raise would be for 123 Main Street and 456 Main Street. And the total capital raise may be 10 million, 20 million, whatever the number is. And your money will go and it'll get pooled into that one fund. Then that fund owns both of those LLCs, which own the assets. Each asset will have what I said earlier, an SPE, a single purpose entity that owns it. So the fund that the investor puts their money into will actually own both of the assets underneath. Some investors like that because it gives them more diversification. In theory, it could reduce risk. Some investors don't like that. Some investors really like doing SPEs. So I thought I would just provide everybody who's on the various types of transactions you may see in multifamily. Then there's another one that is kind of taboo. It's called a blind fund. Not kind of like a blind date, actually. I'm trying to be funny for Kavitha, but I can't really come up with an analogy with blind fund and blind date other than you don't know what you're getting. So it is kind of like a blind date. A blind fund is typically a syndicator or group of syndicators that say, hey, we're going to go out and we're going to buy either a single asset or a group of assets, and these are the parameters we're going to buy them, and they're going to be, you know, mid 1980s, and they're going to be in the southeast corner of the United States, and they're going to be 1980s or larger, and we're looking for 100 units or more, something like that. And they'll put that down in what we'll talk about in a little bit called a PPM, a private placement memorandum, and they'll say this is typically what we're looking for. So the reason they call it a blind fund, or this is called a blind fund, is because in theory, well, in reality, you are blindly giving the syndicator capital to invest in deals they don't have yet. And so there's some things to be aware of in blind funds. First of all, most of them have what are called 100% capital upon signing the documents. So that means if you're going to invest 100,000 or 200,000 or 50,000, when you sign your subscription agreement, which are part of your PPM docs, you're going to have to wire the full amount. So you're wiring them money, and there's no asset to buy. So you're going to have a lot of faith and trust in those syndicators. And I'm going to go over some things to look at in a few more slides when you're looking at your syndicator / partners. There's another type of blind fund that our firm has represented and that investors may come across, where same thing, they've got the parameters, we're looking for these type of assets, but what they do is they don't ask for the money up front. They do capital calls. Okay, this is different from giving money up front and then the asset not doing well and the sponsors asking investors to make a capital call because it needs money. These capital calls basically are, hey, we're putting together a blind fund. We want to know that you're committed for $100,000 over the next 6 months. And the next 6 months, we're trying to acquire, this type of asset. And so when we do, we're going to give you a 10-day notice capital call saying, now it's time for you guys to, pony up your 100K so we can go buy it. The advantage that that some investors like about that is their capital's not sitting somewhere doing nothing. The disadvantage, and what we advise clients, because we get clients that are investors, past investors all the time, that'll pay us to review the docs and notify them of any uh-ohs or things to watch out for. And you have to be careful when you're doing a deal where you're putting 100% of the capital up front and you're not familiar with the sponsor, you run the risk of, if that sponsor feels the urge that they only have 6 months and they can't find anything, they sometimes may go after an asset, or could go after an asset that they really shouldn't go after. So I don't think their intention is probably that, but as time runs out, the general rule as a sponsor, from what I know, you don't like to give back capital if you don't have to. It's hard enough to raise it, so you want to go ahead and deploy it. So blind funds are not for the faint at heart. I would not recommend first-time investors going into blind funds, especially if you don't know who the sponsors are. And we're going to go into, I'm going to use the word sponsors and GP interchangeably, even though most of these are LLCs for any of the lawyers, if there's a lawyer that happens to be on, or a CPA. We use the term LP and GP, though legally the terms are members and managers, but most of the world recognizes LP and GP, limited partner, general partner. Limited partners are passive, general partners are active. They're the ones that are running the deal, and the limited partners are the passive investors. The other thing to look at in a blind fund, there may be a long open period. Open period is simply, every fund has an open period, or every syndication has an open period. Blind funds typically are open longer, 1, 2, maybe even 3 years. What that means is they can continue to bring in capital. Once the fund is closed, that doesn't mean the fund is done. It just means the fund is not bringing capital in anymore. So these are kind of important things to look at if someone provides you or sends you a PPM document and it doesn't have an actual asset they're buying, but it says this is our targeted asset. That should be a light bulb that says, okay, I need to remember what that lawyer was speaking about during Diwali and during one of the biggest weekends of the college football season, that some of the people on here actually were listening to me speak instead of watching football, that, you know, we need to go either talk to some experienced syndicators, or we need to go see a lawyer, talk to a lawyer, have him, her, them review the blind fund. So enough about blind funds. Sponsors. Okay. I was trying to get a picture of Ramesh and Raj and Kavitha, but this is all I could come up with.
Look pretty close, sir.
Yeah, I know. You can pick and choose, and we're equal opportunity. So I actually talk about this on a lot of my other webinars, and it could not be. This is the most important thing you can do as a passive investor. I would argue this is more important than the actual asset itself. Okay, the asset's very important, but who your sponsors, who the GPs are extremely important. You can have a great asset that can be just run into the ground by sponsors or syndicators that don't know what they're doing. So I know this sounds weird, and I tell everybody, especially if you're going to co-sponsor with somebody, and I don't know how many people on here are going to be co-sponsoring, but anytime you're going to do an investment, and these are private investments, so they're kind of closed. They're closed investments. We're not buying stock in Amazon or Tesla and interviewing, you know, the CEOs of Amazon and Tesla to see how they're going to operate. This is different. We're buying an ownership interest in a deal that may only have a total of 40 or 50 limited partners in it, and 1, 2, 3, maybe even 4 general partners. So you want to know what the general partners are doing. And the reason I say that is you can't just go and sell your ownership interest to Ramesh and say, hey man, I got a deal for you because I want to get out of this deal because I don't like the GP. It doesn't work like that. You know, you're in this deal until it's over. And I'm going to talk a little bit about that later. So some of the things I would look at, and we always tell our clients to look at, whether they're limited partners or they're coming in as a co-general partner in a deal, the personalities, you want to make sure that you can handle the personalities and that there are synergistic personalities, just like picking your law firm. Some people like me, some people don't like me, some people like Greg, some people don't like Greg, some like Cindy. You don't want to work with another group that you don't find compatible. It's never a good choice. It's just like a marriage. Experience. that kind of goes without saying. If you're going to invest in someone's deal for the very first time, not your first time, but their first time, guys, these are investments, risk reward. You're at the highest risk level if they've never done a deal before. And if no one in there has ever done a deal before, you're at the highest risk level. So you better have an incredibly good opportunity to make a really high return. Otherwise, pass and go find a syndication group that's got experience. Some people, and I'm not suggesting anybody on here should do that because you'll really annoy the GPs, but as a limited partner, but as a co-general partner, the next thing I think is important, at least some of them, check these people out. You know, it's amazing what you can find on, Dr. Google. Google anybody's name, you'll find the good, the bad, the ugly. And so if you don't find any bad or ugly, that's a good sign. Go to Facebook, LinkedIn, Instagram. All of us are on there. My law firm's on there. These guys are on there. I know Kavitha's on there because I get something from her like every 4 or 5 hours. She's a marketing genius. But check these things out because they're very good. And if someone doesn't like somebody, guess what? That's going to be on social media too, and you'll find out really quickly. You could actually say, hey, I'm putting Kavitha on the spot because she introduced me, but has anybody worked with Kavitha before? And, you'll get what you're looking for. I knew she would pop up. I'm not picking on Kavitha, but there are ways that you can check very quickly to see, okay, are these good people or have you worked with this group before? Credit check and report. This is left over from a prior presentation. I tell clients that are going to go co-GP with others that you should ask for a credit check or some sort of background report because at some point the general partner is going to have to get financing and the lender is going to pull all of these reports and you don't want any surprises. So if you haven't worked with these partners before, you don't want to be 30 days out from closing and all of a sudden, I'll pick on Ramesh. Ramesh has, 4 bankruptcies on his report and he doesn't have any bankruptcies. I'm telling you guys, but someone has 4 bankruptcies and the lender's like, okay, well, we can't use them as a guarantor. They can't sign on the note, blah, blah, blah. It creates lots of problems. So as a passive, I don't know if I would ask for that. But if anybody listening is thinking about being a co-GP or a co-sponsor, it's not unreasonable to ask for it. You may not get what you're asking for, but eventually it's going to come up because the lender requires of everybody. There's a section on capital raising. As passive investors, you may get asked this occasionally. Hey, can you bring in $1 million, $2 million, $3 million? Be very, very careful with that. There are very strict SEC regulations on how you can do that. And highly, highly, highly recommend that you speak with an SEC experienced law firm. Obviously you can speak with us. There are many good law firms out there. But you speak with them before agreeing or doing anything writing about raising capital if you're not already on the GP team. And then I don't know how many GPs would be willing to give passive investors their PFS. A PFS is just a personal financial statement. That's required by every lender when you're going to do a deal. It's required not of the passives, but of the general partners. But again, if you're a passive and you are asked or you want to be elevated to like a co-GP, you're going to need to provide your PFS most likely, and you're going to want to know that the people you're working with have the financial wherewithal to even be doing this transaction. Again, if you don't ask for it now, that's fine, but the lender's going to ask for it, and the lender is going to stop the entire transaction if it doesn't work. So I like to know everything that's going on up front. That's probably my old bankruptcy mindset, where I've already seen what happens when things don't go right. So I'd like to make sure they go right to begin with. So let's see what else we have. You guys may have already talked about this. I haven't listened to the whole series yet, but you're really only going to encounter 2 types of opportunities as passive investors. It's either going to be a 506B or 506C. And Ramesh, has anybody discussed B or C yet?
No, not yet. You can go ahead.
Okay. I'm going to spend like 3 minutes on it because it could be literally 2 hours. There are 2 ways to raise capital as a general partner or a sponsor. you're either going to raise capital under Reg D 506B or Reg D 506C. I made it as simple as possible, and it's much more complicated than what you see on this slide. But bottom line is, if you're not an accredited investor, which means as a single individual, you didn't make $200,000 or more the last 2 years, and you don't anticipate making it this year, or you don't have net worth of greater than $1 million, and you cannot include your house. Those of you that live in California, there are shacks in California that are $1 million. So that's why you can't include your house. You are not an accredited investor. You're considered a sophisticated investor. That doesn't mean you can't invest in sponsors' deals, but what it does mean is that sponsor is only limited to 35 of the sophisticated investors if they're doing a 506B, okay? So it'll say right on the top of your PPM document, this is a 506B. You won't see something on Facebook or social media or radio or even TV commercials for a 506B. If you do, please reach out to me as soon as you can. I love going after people like that. I'm kind of like the social media police sometimes. That's a huge no-no, and that'll get people in big trouble. So we try to prevent them from getting in trouble. So under 506B, again, you won't get a marketing. It would most likely be an email or a telephone call from somebody you already know. You've got to already have had a substantial relationship with that person. And so they can take up to 35 sophisticated investors. 506C, that's the other one that most passive investors will see. And that is accredited investors only. So you have to essentially have made $200,000 or more as a single individual, or $300,000 or more as a married couple. Or if you're not doing that, your net worth has to be over $1 million. So if you meet those essentially three requirements, one of those three requirements, you're an accredited investor. And these you will see on social media. These you may see. Some of these are on CNN and Fox late at night, where you see these advertisements for condo developments in Florida. I see them all the time. Those are 506Cs. It's pretty funny. You should watch them at the very beginning under little tiny font. It says this is a Reg D 506C, and they also put it at the end. It's like one of those late night commercials for really, really old people that can't sleep. Well, they're going after them, and they're trying to get some money out of them to go into their 506Cs. But a 506C, if you're a sophisticated investor, don't even look at it. You're going to create more issues. You have to go through an accreditation process. Some sponsors make it very easy, and they use an outside firm that does it. There's one called Verify Investor that I think about 90% of our clients use. I use. And I think Ramesh and Raj and Kavitha use as well.
Yeah, they use the same. Yeah.
Yeah, they're great. And for our stuff and most of our clients, it's not a fee that goes to the client. It's a fee that's typically absorbed by the fund, but it takes the burden off of the sponsor, because essentially they have to be like a mortgage broker and just verify they meet the requirements. So again, the only point of going over this for passive investors is when you see a PPM or sometimes you may see an executive summary, which would be like a 3 or 4 page kind of email or a memo that says, hey, we have this thing 123 Main Street. If you're interested, sign up for this webinar. We're giving it, blah, blah, blah. If it's a 506C, it should say accredited investors only. Anytime you see accredited investors only, 99% of the time, it's going to be a 506C. If it's not a 506C, that just means the sponsors don't want to have anybody that's not accredited. Legally, a 506B can, but again, that's still up to the sponsors. It doesn't say they have to. It says they can take up to 35 sophisticated investors. So now that I've put everybody to sleep, let's see if I can wake people back up. These are the fun things, and this is a touchy subject because I charge some of these. Everybody charges some of these, and it's based on experience as a syndicator, and it's based on the deal. If the deal's really good, you'll see these. So I'm gonna go over these real quick. I don't know if they've already if anyone's gone over these, but it'll take a second. Many times you're looking at a PPM or you're looking at a investor presentation, and it'll say acquisition fee. These are fees that the manager gets. When I say manager, again, I'm using it interchangeably, sponsor or GP. Okay, so acquisition fee. Just keep in mind, I'm taking off my lawyer hat for a second. This is a fee.
Sorry, could you say that again?
Apparently Siri didn't like that. This is a fee that, throw that away. This is a fee that the sponsors get for finding the deal. And those of you that are passive investors listening, make sure you keep in mind that this deal that your sponsors have found is one out of probably 15 or 20 that they had to look through to get. And then they had to spend enormous time on due diligence. So you may see anywhere from 0 to 2%. And we're seeing more often than not now, as the cap rates are shrinking and the deals are harder to find, people going with 2% as an acquisition fee. Whether you want to invest in a deal like that, that is up to you. I can tell you, if you're a passive investor, those are not negotiable fees. That's already in their PPM documents. So these are things you need to be aware of. There's also what's called an asset management fee. And typically it's based on revenue collected. Sometimes it's a performance fee. Very rarely in this circle do we see performance-based asset management fees. They're typically a % of revenue collected each month. And those range from 1.5% to 3%. Most of them are in the 2% range, but it just depends on the deal. Less frequent, we see refinance fees. So you have a deal, you're under market rate, so your value is, there's a lot of potential equity in the deal. You remodel, 15, 20, 25% of the units, you get those up to market rate, you go get a bank to revalue you. And they say, okay, look, we can refinance you, and you're going to be able to pull out whatever, $4 or $5 million, $3 million. You pay that back to your investors. But that work that it takes to do that refi, some sponsors charge nothing. Some charge half a point. Some charge a point. I've never seen it higher than a point. But again, I don't see many of these fees. But it's something you need to be aware of when you're looking through the PPM. There'll be a section in there that talks about fees to the manager. So you want to look. If you don't see it, there is nothing wrong with you asking about any of these 4 fees on this sheet. I get asked it all the time. I'm sure the panel gets asked it all the time. So there shouldn't be any problem discussing it. And then there's, which we are seeing more often of, an exit or a disposition fee. Disposition fee just means selling the asset. It could also mean liquidating in bankruptcy, but we don't like to use those bad words in the context of this type of presentation. So we don't use the B or the L word. These are sales. So when we're talking about disposition, we're just talking about sales. And so when you go to sell the asset, many times you'll see a disposition fee. Most of the time when there is one, I've seen it at 1%. And so, you bought the asset Main Street for $20 million. You're selling it in 4 years for $30 million. So the manager is going to put a 1% disposition fee, which means they're going to take $300,000 from the proceeds for their time and effort in working with a potential buyer, dealing with the lender and whatnot. Whether it's justifiable or not, that's up to you as an individual passive investor. I'm telling you, as a law firm, maybe 20 to 25% of the deals that we're working on have disposition fees. I'd say maybe 5 to 10% have refinance fees. Every single one has an asset management fee, and about 90% have some sort of acquisition fee now. So those are fees that you guys should be aware of when you're looking through a PPM. And Ramesh, just give me an idea on time, because I just threw my Apple Watch into the wall.
No, it's okay. You're doing good on time. Yeah.
Okay, good. So one of the things also, don't be nervous if you see all these fees, because the fees typically are based on how good a deal it is. For experienced sponsors. For inexperienced sponsors that don't know what they're doing, they may throw all these fees in, and the average return is like a 12 or 13% to the investor. I can't tell you what to do, but I think the panel would tell you to go run from something like that. If they're charging a 2% acquisition fee, a 3% fee. I used to have a shirt, this is 5 years ago, that literally said, everybody's got shirts now that say rents due. My shirt said fees, 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 fees. And this is like, I was making fun of myself when I was doing the single family business on the side. We built a whole company out of it, and we got an acquisition fee, we got a rehab management fee, we got a sale fee, we got to set up the utility fee, we got fees for everything. So be careful. The only reason we got fees is because we were buying properties at such a good deal, we could justify those fees. So these will be in your PPM. They also have to be listed in the company agreement that you're signing as well, which is part of the PPM documents. Let's see. Real briefly, I'm sure that there's been a person that's spoken about this already, but typically when you're an investor, just check out the capital stack. It'll be in the investor deck, the investor presentation. Capital stack basically means what are they using to buy the entire project. That includes any rehab dollars. So there are only 3 types of capital that you're really going to come across. Capital, private capital, which is what everybody listening would typically put into a deal, you know, your cash. Debt, kind of self-explanatory. It's agency debt, Fannie, Freddie, CMBS, which we really haven't seen much of since COVID started. CMBS is down to maybe 5. I think last thing I read was 5 to 7% of all deals are CMBS. They're like Wells Fargo, some large bank deals. Agency is Freddie or Fannie backed money. Typically they're the cheapest. And your sponsor is always going to look for the least expensive capital stack. So that'll, as we said earlier, it's typically going to be 70 to 80% of the deal. It typically has to be disclosed, maybe not the exact rate, but how they're getting financed in the PPM and the company agreement. And then you have private money and bridge. It's pretty funny. Bridge 3 years ago was a no-no. You never use bridge. Bridge was like 7-8%. Horrendous terms. Now, since COVID, bridge is coming in almost the same as agency, much better terms, no prepayment penalties or no real prepayment penalties, and interest only. So you'll see at least over the next 12 months, if not longer, a lot of deals that will be coming to this passive investor group will have bridge financing on it. So don't be nervous if you see bridge financing. They are floating rates. I'm not going to go into detail about it, but if you do see bridge, one of the questions I would ask as a passive, if you don't see it in the documents, you know, is there a cap? Did they buy a cap or did they buy a lock on the floating rate? You know, so right now, yeah, 3.5 is great, but if something dramatic happened and it could jump to 5 or 5.5%, that could really kill the deal in the future. So something to look out for. Very few of you are going to see this, but there are more and more deals that are starting to utilize preferred equity. I have a whole webinar on YouTube about this, so I'm really not going to go into it other than it's another type of capital that sits between private capital that you guys would put in and debt that a lender would put in. So, you know, you may get an 18 to 20% ROI as an investor, and the debt is going to come in at 3.5, maybe 3 3/4, you know, somewhere in that range. And then preferred equity is going to be around 12 or 13%. And typically preferred equity comes in between, debt is going to be 70-75% of the total capital cost, capital stack. Then preferred equity will go all the way up from wherever debt stopped at 70 or 75%. They'll go up to typically 85% of the total cost. So figure another 10%. Then the remaining 15% is going to be capital. And you know, if you looked at it on a chart, basically, you know, 3/4 of it is going to be at 3.5%. An eighth of it is going to be at 13%, which is your pref equity, and then your top piece is the private capital. You guys as passive investors, and you get paid the most. You're the most expensive capital that's in this deal, but you're a necessary evil for sponsors. Not that you guys are evil, but can't do the deal without the private capital. So you may see some deals that have preferred equity. If you do, highly, highly, highly recommend you seek legal advice on it so that they can explain to you how it works. Sometimes it's not even in the documents. It's just kind of a footnote because pref equity is actually not part of the fund itself. It sits out on the side. So you want to know how that's structured. I don't want to confuse anybody or complicate things. You guys are welcome to reach out to me, www.kaliserlaw.com, and ask. And I've got a whole webinar that just talks about pref equity that'll really bore you. Let's go next slide. Waterfalls. Oh, I had the best webinar for waterfalls. It was TLC. I don't know if you guys remember TLC, Don't Go Chasing Waterfalls. So I had the music. It was great. And I forgot that was back in the 90s. I must have only been like 5 years old back then. But I forgot that they didn't have really good photography and video. And the only picture we could pull from the internet was this. I mean, it looked like a sixth grader had drawn it with crayons. But it was one of my biggest attended webinars, because we kept advertising it as TLC was going to be on talking about waterfalls. So I did. I had TLC's video on for like 10 seconds. Don't go chasing waterfalls. So there's a point to this, I promise. Waterfalls are probably the biggest thing as a passive investor that you need to be aware of. And waterfalls, nothing to do with water. It's just a dollar comes in of profit. How is that dollar split up between the LPs and the GPs? It's that simple. People like to use fancy terms. I see I forgot a comma between the 3 and the 4. People like to use fancy terms, but it's simply dollar comes in, 20 cents is going here, 80 cents is going there. So when you look at waterfalls, how many classes are in the fund? The easiest fund you will look at has 2 classes, an A class and a B. A are going to be the limited partners, the investors. B will be the sponsors or manager. Okay. You may also see what's called a preference. And this can be tricky. Again, you want to read the documents very carefully. If you don't want to read the documents that carefully, never tell somebody, oh, I just trust you. Never tell the sponsor, I trust you. You know, it must be a good deal if you're telling me it's a good deal. Read your docs. Preferences are where people misunderstand what's going on. So you may see in documents, this is probably a little bit old now, anywhere from a 5 to a 10% preference given to investors that invest in, for example, Class A. What does that mean? So it means theoretically that if there is a 9% preference, that means of the proceeds or the profits that come in and proceeds on a sale or refinance, that Class A should get the first 9% of the capital they have invested in the deal back as a preference, as a return. Okay. If the deal only produces a 7% preference in year 1, again, look to the documents. Most say this, but there's some sponsors out there that don't do this. Whatever they didn't get in year 1 should carry forward to year 2, 3, 4, 5 until the fund makes enough money to give them an annualized 9% preference. The other thing to look out for, and this is kind of tricky, when we do documents, we actually bold this. Sometimes our clients don't like it, but I do this to keep our clients out of SEC trouble. Anytime you're trying to hide something or put something buried in a paragraph, that's when sponsors get in trouble later on with the SEC. So sometimes there's what's called a catch-up clause. So not catch-up, but catch-up. This deal, this is a little interesting. So the same deal, 9% preference, which means the investor gets 9% first. And then let's say it's a 70-30 split. 70% of every dollar afterwards goes to the passive and 30% goes to the sponsor. Okay. On a deal that has a catch-up, 9% goes to the investor first. But once that 9% is hit, then the sponsor gets to catch up as if the entire thing was a 70-30 split. So I'm not trying to confuse anybody, but there's a big difference in the return to an investor between a 9% true preference, where they get the first 9% annually, then everything is split 70-30, and a 9% preference with a catch-up clause. Because a 9% preference with a catch-up clause, all it says is the investor gets their share of the 70%. In other words, 9% of that before the manager gets caught back up. So one has the manager catching back up. The other, the manager doesn't even play until the investor has had their 9% first. So as a passive, I didn't want to ask this question, but obviously, what would you want? You probably want the first. You want to get your 9%, then let the manager pay, let the manager play. And by the way, anybody that has questions while this is going on, please put in the Q&A. We'll go over the questions at the end. And I apologize, I'm losing my voice. I was in Florida for a few days, and just I don't know why my voice is going.
Too much partying, Merrill.
I wish. It's too much working, actually, on this PowerPoint. So the other thing to look at in waterfalls, I have fixed return on investment versus performance return on investment. And actually, our deal that we're in together, we had a class A that had what's called a fixed ROI. So you will see more often right now where there's a class that some deals investors can invest in, and they get a true preferred return. That preferred return means they get their 7 to 11%, whatever it is in that particular class, they get that first before anybody else gets their money. Or they're guaranteed, I can't say the G word, they are highly, highly, highly preferred to get their 11% before the others get their money. The downside is they get nothing on the back end when there's a sale. So if you're an investor that doesn't want to hedge the risk of not getting as much on appreciation on the back end and really wants the cash flow, and that's why you're in the deal, then if the deal has a preferred return, that might be something you want. Don't get confused between a 9% preference 70-30 split and an 11% preferred return. The 90%, the 9% preference 70-30 split, if the deal does what the sponsors think the deal will do, typically will produce much larger return than 11% on an annualized basis, because the property will be sold and that 9% preference class will get whatever 70% of the sales proceeds, the net proceeds. But you will see deals, I would say about 20% of the deals that we represent right now have a preferred return class. Typically, you'll see a lot of the older passives, even older than me. I'm 52, so maybe like Ramesh's age. I think I may actually be older than Ramesh, but you may see people like in their mid-60s, mid-70s that want to get involved, but it's like a coupon. They want to clip a coupon and they can't buy bonds. CDs are paying 0.75% annually. So this is the closest they can come with the least amount of risk. So you may see a deal that has a preferred return in the PPM. If you don't understand it, ask the sponsor. If you don't ask the sponsor, groups like my firm, it's not a huge portion of our business, but we probably get three or four investors a week that will ask us to review a PPM, as long as it's not one that we prepared. And I think we charge an hour and a half of our time, go through the PPM. And if we see something like a fixed return or a preferred return or a preference with a catch-up, these are things that your lawyer should note for you as a passive investor. We assume you don't know this. And so don't get mad at the law firm, whoever's representing you guys, if they seem to kind of lay it out like the ABCs, because we'd rather you be taken care of than miss something. And then hurdles. You may have some deals. It's basically the 9%. You may have a deal that's a 9% pref. So the investor gets their 9% first. Then it's a 70-30 split. Once the investor has a total annualized return of 15%, then the split may go to 50-50 or something like that. I see everybody's on. Are you guys telling me to hurry it up? Okay. And then
No, you got 25 minutes more.
well, I'm going to slow down then. I'm just kidding. So this was just, you guys, I don't know if you're making it available to people later on to review this. You can take a screenshot. This is just simply an example of how some of these look. You may have a preferred equity deal that gets 10%. This is like what I just told about, not really preferred equity, it's more like preferred return, where you just invest and you're going to get 10% a year, presuming that there's the return to pay the 10%. And typically, if it's not there, Your PPM docs should say that it accrues and will be paid first before the rest gets paid. And if that's a 5-year deal, you're going to see in the PPM a 1.5 multiple. All that's saying is they anticipate that you will get 1.5 times your money back. It should say anticipate. If it says guarantee, please show me that one. I'd love to see the firm that put the G word in their PPM docs or company agreements. Guys, anybody that ever sees a guarantee in a deal, don't invest. That doesn't exist. There's no guarantees except taxes and death. I don't remember who said that. So this is just a summary of the.
Franklin.
Who said it?
Benjamin Franklin.
Oh, I wasn't around, but Ben said that. Old Ben. Exit strategy. Okay. There's nothing to actually put for exit strategy other than I put it as large as I possibly could, so everybody would understand this is almost important as your waterfall. How in the world are these sponsors going to get rid of this property? And I say that in a negative way. It's not meant to be negative, but they've got to have a strategy. And if I'm a passive investor in a deal, I don't want an exit strategy. I want exit strategies, because I'm not a fortune teller and I don't go to Vegas. Probably the only one on here that doesn't go to Vegas. I don't like to gamble much, and so I'm risk adverse. So I don't want you to tell me we are definitely selling this in 5 years and this is what we're selling it for. I want you to give me ranges. This is what we can do. Worst case, best case, average case. And if we can't sell because the market's not right, what are you going to do? Oh, you're going to refinance because that's in your PPM. You want to see their exit strategy in their PPM, or at the very minimum in their investor presentation when they're doing their webinar, or if they're sending you out a 50-page deck. And you guys didn't hear this before, but Kavitha and I were talking about, a lot of these PPMs, the entire package can be, she said 150 pages. We've done some that are 230, 240 because they're multiple assets. And I would say 15% of our investors in our deals are physicians. And my dad's a physician, my father-in-law is a physician, and hopefully none of them are listening right now. They never will read 250 pages, ever. Their attention span on this stuff is like 10 minutes, 15 minutes, because they're too busy. They've got other things going on. So, one of those things I tell passive to look at is you want a PPM or investor presentation that is styled very similar to the KISS method. And those of you that don't know what the KISS method is, it's keep it simple, stupid. Not saying you guys are stupid, but it's got to pop. If you don't understand what that sponsor is saying on the presentation, or you're reading through the PPM and you read the whole thing and you still don't know what you're supposed to make or how this is going to turn out, you have 3 options actually. Call up the sponsor, and they're not going to enjoy talking to you, but call them up anyway and see if they'll explain it to you. Have a lawyer go through it, explain it to you, or pass and find a deal that is presented in a way that makes sense. I would probably suggest the first 2 before you pass, unless you're a very experienced passive investor and you see a PPM that makes no sense. You don't even have to talk to a lawyer. If you've already read 5, 10 PPMs and number 11 looks just completely off the range, just move on. It's not worth it. And I hate to say this on a recording, but it's not worth the legal fees. You can delete that later, Kavitha, but I said it's not worth the legal fees. Oh, this is the fun one. Okay, so actually Kavitha wanted me to talk about what's inside the documents, and I haven't mentioned anything really about it. So this is what we say, because it's only been one slide. This is what we say to investors. This is what I speak about all the time, what to look for in your company agreement. And this is for an hour legal work or an hour and a half legal work, if you want a law firm to do it. These are the things that our firm always points out to passive investors when we're looking at a deal. Capital calls, mandatory or non-mandatory. That's a big deal. If the investment goes bad, are there mandatory capital calls? That means everybody who's an investor has to put in 10% more. And if you don't, you get diluted, which is the next thing. You didn't sign up in a deal to be diluted. Now, if it's a non-mandatory capital call and you decide you want to put capital in to help out, that's your option. But you want to be very careful, and there are, I'd say 10% of the deals that we represent, the sponsors have mandatory capital call provisions. Have I seen them utilized? Maybe I've seen that utilized 10 times out of over 1,000 deals, so less than 1%, but they're there. Self-dealing. This one's tough. I hate to say it, but almost every deal as a passive that you're going to look at is a conflict of interest in and of itself. Okay, because there's inherent conflicts of interest between the sponsors and the passive investors. The idea of the sponsor is to minimize that conflict by being as transparent as possible, and we try to advise sponsors be overly transparent so there's no question. As an example of a conflict of interest or self-dealing, I'm going to pick on Raj because he's the only face I see on the screen. Raj goes and does a syndication, has a $10 million asset. It's doing well. And he's got somebody that reaches out to him and says, hey, Raj, I've got an $8 million 1031 exchange, and I need to place that in the deal. Raj says, I can make some money on this, so maybe I'll sell this asset right now, pay my investors off, and then I'll buy it from myself, and I'll create a new entity and I'll buy it from myself, because then I can put my buddy in as 100% of the capital and the two of us run it. Now, that technically creates a conflict. Did Raj sell the asset at fair market value? Did Raj complete the business plan on the asset? Sorry, Raj, I know you wouldn't do this, but I just have to. Kavitha's on, so it was Raj and Kavitha doing this together. Kavitha was the $8 million 1031 exchange money. But the point being is, in most of our deals, we have a section in the company agreement that says everybody acknowledges there may be conflicts of interest. One, you may have partners that are working on other deals. GPs have multiple deals. If they're successful, they've got more than one deal. And so you cannot expect 100% of the GP's time on this particular deal. That's why they have third-party property management and third-party construction and maintenance. But you need to understand, especially if you're getting into a new construction deal, many times those are in phases. You have phase 1, phase 2, phase 3. Phase 1 is a group of investors to help get the land to shovel ready. They then sell it essentially to themselves for phase 2, because now they're going to build and they're going to need to raise $15 million versus the 2 or 3 they raised before. And so in order to avoid that, we advise clients, don't have a split. If you know you're going to sell it to yourself later, don't put a split in there. Put a fixed return. We will pay the investors up to 20% return on their money, provided the proceeds are there. Okay. Or we're going to pay you 20% when we sell. So if the investor knows day one, they're going to get 20% per year as long as their money's out during phase 1, great. You could be phase 1 could be $2 million and you sell it to yourself for exactly equal to the 20% because you want a really low basis in that deal. Great. Or you're a sponsor and you want to make a lot of money on that sale, and you know the lender is valuing it really high. So you essentially sell it for a 60% return. But you told the investors and they agreed they only needed to get a 20%, they were only going to get a 20% return. So that's what you would see as a fixed return. And that's a way to avoid self-dealing. You disclose up front what you're going to do. And so there's no question as to, oh my God, you never talked about this. So, and typically we like to have those type of provisions, maybe not bolded, but all capitalized when you're looking through a PPM doc. So just note to selves, when you're looking through a PPM doc, anything capitalized or bolded should always stand out to you. Just read them. Even if they don't really pertain to you, there's a reason why they're capitalized and bolded. It's to protect someone's rear end. And typically not to protect yours as the passive, it's to protect the GP. Then the other thing, the 3 Ds. I don't know if everybody knows about these, but every company agreement has the 3 Ds: death, divorce, and disability. I said there were 2 certainties, death and taxes. Well, so there's a 53% certainty, probably higher now with COVID, of divorce. And so you want to see, if you're a passive investor and you're happily married today, you want to see what happens if there's a divorce. How are you treated as an investor? So there typically will be 5 to 8 paragraphs in the company agreement. It won't be in your PPM. It'll be in the company agreement that you sign that talks about death, divorce, and disability. Whether if you die, does that interest transfer over to your estate, or does the LLC have the right to buy it at face value, at fair market value? These are sections you want to read through in your company agreement. If you don't understand it, don't ask the sponsors, because they're not lawyers and they should not be giving you legal advice. If you don't understand it, you need to talk to a lawyer. They'll know very quickly. These are things that we point out. The other thing, voting percents. This one is a really good. This one's a really good deal. Always look at the voting percents. You have 2 types of votes. You have a majority and a supermajority. Majority is 51%, right? It's 50.1% is a majority. That's simple for everybody. Supermajority can be defined any way the sponsor wants it. I've seen 52%. I've seen 67. I've seen 85. I've seen 60. Look at the majority and supermajority. Also, guys, you're typically investing in LLCs. These are not inks. You're not buying stock, which says you have 10 shares means you have 10 votes. In an LLC, you could own 10% of the interest as a passive, but your voting right could only be 1%. It depends on how it's structured. So always look at Exhibit A in the back of the company agreement, which shows if there's a difference between your ownership interest and your voting interest. It also should be defined in the first section of your company agreement where you have definitions. It will say Class A voting interests are blah, 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 or Class B voting interests are blah, blah, blah. If you don't see that, ask where it is. If the sponsor can't point to it, then you probably want to go look for a different deal because they had subpar legal advice, or they advised their counsel to leave it out. Either way, you'd want to go do another deal. And then these are things that I know the panel would tell you anyway. If you're investing money in a deal, you should think about running your own pro forma with the numbers they're giving you. You know, you don't have to run a 27 tab pro forma like Kavitha does, but you should run your own pro forma. There are plenty of people out there, and there are plenty of ways to find and to create pro formas. You want to check their numbers. 1 for accuracy and 2 for fraud. I hate to say it, but there are more social media posters promising or stating returns that don't match their pro formas. So you want to run your own pro forma. And if someone says you're getting a 2.5x return after 3 years, you want to run the numbers and see. Part of that is, and we see it in most PPMs now, every PPM should typically have pro formas attached or the investor presentation attached. And that's one of the reasons why they become really long. Those can be, I've seen some that are 90 pages long, just the investor presentation, but they should have a stress test analysis. These became very popular once COVID started because nobody knew what was going to happen. And so the key was, how far does vacancy have to go before we have and normally, maybe as sponsors in the back of their heads, they were thinking this, but they would never put this in writing. A lot of things have changed since COVID. So now on, I would say the majority of deals that we represent, they put a stress test analysis, good, average, and best. Personally, if you're a passive, I don't really care what best looks like. That's pie in the sky. I want to know what the worst case scenario or a bad case scenario and average. And it's again, me being a former bankruptcy lawyer, I assume worst or average. And if it comes in better than that, I'm really excited. But they should have a stress test analysis. And so you want to look for that. That will not be in your company agreement. It may not even be in your PPM document itself, but it should be somewhere in your investor presentation. If you don't see it, ask the sponsor for it. If they tell you they didn't do a stress test, go find another deal. that's not somebody you probably want to invest with, but I would leave that up to the panel to make comments on that. That's me at the top, the very handsome picture from probably 20 years ago. Cindy is a partner of mine. She's been a lawyer with me for 8 years, and baby Greg is no longer a baby. I took him right out of law school. He looks like he's 12, but he's actually 30. Very good, and he's not listening, so I can have fun with him right now. And that barcode right there, so everybody that scans that barcode, they get $1,000 right now. I'm just kidding. That's if you want to register to get our newsletter. We do a monthly and quarterly newsletter on changes in the law and you know what we're seeing in different SEC transactions, Reg Ds, you know, any type of change. They just made some changes to accredited investors. So if you're a sponsor and you've got a team and some of your team members that may not meet the accredited status want to invest in your deal, it's now legal for them to invest in the deal. They do not have to be accredited. So I like that because I have a whole real estate side that I do, and I have people that don't meet the accredited status and they want to invest in 506Cs. I don't like 506Bs personally, but they want to invest in 506Cs and they can't, especially invest in ones that we might do. So this new provision that the SEC came down helps them out. Also allows your accountant, if he or she wants to invest in your deal. One shot, if you ask your accountant if they want to invest in your deal and they say no, maybe you should have them look at your pro formas, because there may be a reason why they're saying no. So that's embarrassing. There's only one chat or 6 questions, but I'll open it up to you guys in the panel if there's any time.
Thank you so much, Merrill. This was very informative and a little fun along the way. You didn't have to try so hard, though. You're just funny when you talk. We appreciate that. Sid has a lot of interesting questions. We'll take a first one from him. What legal recourse do the LPs have to safeguard their investment if all GPs decided not to continue with the syndication? What kind of backup plans do the legal documents include or should include? What backup plans should LPs be asking for? Could some of the LPs then try to manage the syndication through selling it off?
So somebody wants 1 hour of free legal advice. So I can sum that up very quickly because it's free. I won't take an hour and charge you. Good question. So most state laws provide, most business organization codes provide that if a manager or a GP is not doing his or her job, they can be removed. This is why I focused heavily on what is the majority and supermajority vote. Removal of a manager takes either a supermajority or a unanimous vote. That will be decided based on either state law or what's in your document. If it's not in your document, it reverts to state law, which typically is supermajority. If it's in your document, whatever's in your document trumps state law. So the short answer is you can remove the GP and either elect to put your own GP in, or the group can operate the transaction, the asset. However, big caveat, you're a passive investor because you don't want the responsibility nor the liability of a GP. The moment you start acting as a GP, whether you are legally a GP or not, you have assumed automatically the liability that the GP has. So careful what you're stepping into or stepping on if you live in Texas. So I have to throw a little joke in there for Kavitha. But you're going to step in the shoes of the GP. So you have to be very careful. I always tell people, careful what you ask for. Grass is not always greener, but if the GP is committing fraud, yes, or negligence, yes, you can remove them.
Okay, that makes sense. This is an interesting one. I've heard this a lot lately too, and I think our audience would benefit from understanding this. Heard about qualified purchaser status. How does this differ from accredited investor?
Anybody know? Do one of the three of you know? I'll give an iPad to the one of the three that knows the difference.
I know
$5 million.
$1 million in net worth for qualified purchaser, and accredited is $1 million or more, excluding primary residence. But qualified, they have to have $5 million in investments.
My iPad
My iPad is not working, Merrill.
Okay, so Kavitha's not right. You want to give it a shot? She was very close. It's so close.
5 million.
Nobody look it up.
No. Anyway, Merrill, you go ahead.
Okay, so Kavitha, you are like almost there. So it's 5 million of liquid assets. So the qualified purchaser, what that does is, if you were doing an investor sponsor and you didn't want to even mess, you can actually do a syndication in theory without doing a 506C or B if all your investors were qualified investors or family offices. That's essentially what it is. It's 5 million in liquid assets. In other words, 5 million in cash or more. So them investing in a deal, they are way above an accredited investor. And so they're held to a much higher standard of knowledge than your accredited or sophisticated investors. Those are like unicorns. We love to see unicorns like that. I haven't been so lucky to find any qualified purchasers, excuse me. But yeah, that's a whole different level. And it really doesn't go up from there as far as the way the SEC classifies investors. I'll get you half an iPad, Kavitha.
What's the charging?
I'll get her a mini.
Hey, Merrill, one question is asked is, do the limited partners get to see the charters financials of the manager entity from time to time? And is there a practice of keeping an independent auditor by the company for such syndicate investments?
Those are awesome questions. So yes and no. Yes to the first question about the financials. Here's the deal. If you don't ask for them, detailed financials, sponsors aren't going to give them to you. They're going to give you a summary. By law, though, you're entitled, if asked, to be provided with those financials at a reasonable time and reasonable expense. That's typically what every state law says. But the practicality is typically you're going to get a summarized version of either monthly, most of the time it's quarterly financials. If you want to see monthly, great. Not a whole lot you can do about it. I can tell you from experience of our clients, you do get that one investor that wants to see the monthly financials who's invested like 50 grand in a $10 million capital raise. And they want to know why there was $3 a pin spent, on January 6th. More likely than not, that'll be the last time that investor is asked to invest in a particular deal with that sponsor. So I would cautiously state that, yes, you're entitled to it. I would look at the quarterly financials. If something looks strange in the quarterly financials, absolutely ask for it. Or there are some that there's some sponsors that do produce the monthly financials. The problem with monthly financials, though, is as a passive, you don't realize if you're looking at monthly financials, they're already 30 days behind because you've got to get your statements from the property management company. That's anywhere from 15 to 20 days into the following month. Then you review them, you give them edits because they do make mistakes. And then that next month, you're going to give your investors the financials for 35 days ago. And meanwhile, you're already into 2 months later. So yes, and then as far as audited financials, there is no law under 506B or 506C that says financials need to be audited. And I think it's interesting that investors ask that, but if you told investors that costs about $45,000 a year from a CPA firm, and that $45,000 a year comes out of investor proceeds, most of them wouldn't want audited financials. Now, if you're Amazon or you're doing a $300 million deal and you're bringing in tons of investors or even some qualified purchasers like family offices, they may require that you have audited financials. Okay. Then a $45,000 annual fee is not that much compared to the $50 million you brought in capital. But I would never expect it on a smaller deal. Never.
I think there's another question here, which was interesting. I think they asked the financials of the manager entity, not the financials of the property. Do you ever provide financials of the manager entity?
No, not unless I'm being deposed.
Yeah.
So it's none of their business. They're not an owner and the manager.
Right. That's what I thought. I knew that wasn't the property entity that they're asking about. So usually we require the property entity financials, not the manager entity financials.
Right. I didn't hear that part of the question. Yeah, absolutely not.
This is another interesting question. Have you heard of evergreen funds? Are they synonymous with blind funds? Differences?
Yeah, no, that's a good question. So I didn't put evergreen in there because I didn't think anybody was going to ask something like that. But of course, I don't put it in, someone asked. So evergreen fund would have been the fund I would have said right after blind. All an evergreen fund means is it's open until the manager says it's not. So I've personally done 2 of my own evergreen single family residential funds where we're buying, we're rehabbing, we're leasing up, and we're selling. And we do it again. We rinse and repeat, rinse and repeat. So there's constantly, we're needing additional capital to expand. We did that in some of our deals back in the mid 2000 teens. And those were called evergreen funds. We continued to raise capital and gave investors the opportunity to roll their capital back in as we expanded and bought more assets and then sold them and bought even more. And then 2018 came and we decided we were done doing that. And so we utilized our provisions in the evergreen fund and said, as of this point, this fund is no longer taking capital and we will be winding down from this point on. So all an evergreen means is there's no time frame designated in the company agreement or in the PPM as to when the manager stops raising capital.
Oh, makes sense. Surabhi asked an interesting question, and I think this would be good for all of us to understand. Can we do a syndication after purchasing an asset? I know the answer is yes, but I'll let you talk in detail about that.
Wait, I'm sorry. Can you do a syndication when?
After purchasing an asset.
You say after? Yeah.
Can you buy an asset, let's say as an investor, as a GP, and then syndicate it?
Oh, yeah. Yes, all you're doing is you're recapitalizing your asset. So for people on listening, the easiest way to analogize that it's like a cash out refi. You buy a house. It's like people that flip houses. We'd buy houses for cash real quick because we'd have to make a decision in a day or two, and then the next day we'd come in and have the bank essentially pay us 70% of the value of that house as a loan, so we could get our 70% cash back out. It's the same idea with an owner. If you were able to find a great deal, let's say at auction, a multifamily at auction, and it was $2 million, it was worth like $4 million. And the only way to do it is you have to pay cash right there at the courthouse steps, especially if you're in Texas. So you pay $2 million in cash, then you do a syndication, and that syndication is to raise $2 million and finance the other $2 million at a loan, 50% to get your cash back. Absolutely, you can do that. We've had clients that do that.
That's interesting. I heard about that recently. I'm like, oh yeah.
Yeah, just recapitalizing.
Buying distressed asset. Okay, the person who asked that said they're buying distressed assets. So thank you, Surabhi, for the question. I think we'll wrap up with this last question, which is an interesting one also. Some sponsors have seen in the past also purchase Class A shares or LP shares on top of Class B shares, which is GP shares, to protect themselves from being voted out of the sponsorship for a deal. Is this a common practice? Thoughts on this?
That would only be a common practice if the sponsors had bad legal counsel and didn't understand how they should structure their voting interests. I don't know if that's a question from a personal experience or just thinking about it when they saw a deal. And I'm pretty sure you guys are the same way. If you're sponsoring a deal, there's not a deal I ever sponsor that I don't buy LP interest, and I don't buy it for voting rights. I buy it because I believe in the deal, and I also buy it to show investors, hey, I'm not just asking you to put your money in it, I'm putting my money in it. So I personally don't know of anybody trying to buy votes unless they really screwed up with their law firm and for some reason, I don't know, wanted to buy votes. To me, that's a red flag. If you saw a sponsor at the time of syndication buying interest to shore up their vote, go find another deal. That sponsor has got issues from day one. Go find another deal.
Yeah, that makes sense. Yeah, if the legal documents are written right, that shouldn't be an issue already. So,
right.
I think investing as an LP from a sponsor is a good thing, not a negative thing, right?
Right. Yeah.
And the last question, and we're going to wrap up with this, what legal recourse do we have if all the GPs decide not to continue? I know this was asked, but he restated and he said, originally asked, this wasn't answered. What legal recourse do they have?
Do the LPs have if the GPs quit?
Yeah, decide not to continue with the property.
You remove them. It's the same answer as before. You simply remove them. Your document provides for, you can call a vote, and it can be a vote by proxy. Every company agreement should have it. There's a mechanism to call a vote. You remove the GP and you replace the GP with someone else who can operate the property. And again, caveat, whoever steps in is going to step into whatever they just, whatever the GPs just left, you know? And look, it's not as easy as that. You have to notify the lender. You got to call the property management company. If you have pref equity involved, you have to notify them. There are a lot of things that have to happen along with that vote that the LPs have to do. You can't just step in, because if you remove the GP, you're in breach of your loan docs, and that's a no-no.
Okay.
And that creates the level.
If you have more questions, you know where to reach Merrill. Scan the code or go to kaliserlaw.com. We're going to stop here because you got an hour and 20 minutes of free legal advice. So I think you got your money's worth here. So thank you so much, Merrill, for being here. We appreciate your time. And I don't know what that $1 per hour is, but it's high. So thank you all for your feedback on the session. Everybody loved it. So thank you so much, Merrill.
Great. Thank you for having me.
Thank you.
Thank you, Merrill.
Thank you for joining us at Passive Investor Ed.